All right. Let's see how many of you can actually hear me. If you could raise your hand in the GoToWebinar hand raising, control panel, it would make me feel better. And I don't see any hands going up quite yet. My equipment, oh, there we go. Thank you very much. Always good to see that. All right. So welcome back. Oh, question. I can hear you. So welcome back. What we're doing today is we're proceeding through our short little discussion of the residential purchase agreement. And it's okay. Just multitasking. All right. And this is where we left off. By the way, these have all been recorded. I'm doing more sessions. You're welcome to sign up for them and watch a copy of the recording. I only charge like $2 to watch a copy of the recording. I have never mind, that's not true. So what we're doing now is we're on paragraph 4 of the residential purchase agreement. And what it starts off with is a contingency called the sale of property contingency. This is not a financing contingency, but this agreement, it says to obtain financing is not contingent on the sale of any property. But if we check the box, it says the agreement and buyer's ability to obtain financing are contingent upon the sale of property owned by buyer. Right? So this has one of the magic words, and it's the word contingent. This is called the COP, which has to do with the sale of the property contingency. Now, let's say the market slows down a little bit. It may become more common where people are making offers that have contingencies. And one of the contingencies sometimes is I have to sell my house in order to buy your house. And sometimes that manifests on the other end where the person is selling their house doesn't want to sell their house unless they can find a house that they want to buy. Now, this particular form can be used, if you click that box, for either scenario. Either I don't want to sell my house unless I find a house I want to buy, or I don't want to buy the house unless I am able to sell my house. Right? Now, if we might have time at the end of this to go through some of the forms, but if you click on that box and it loads that form, it's going to ask questions of the buyer like, is your home already on the market? Are you already in escrow? And things like that. Now, if you're making this contingent upon the sale of an existing property of your buyer, which the buyer has not put on the market and is not in escrow, this is a pretty weak contingency. One of the topics that I cover with people that I coach and mentor is what do you do when somebody, let's say it's a listing, and they don't want to sell their home unless they know they can find another home. And so they'll say, well, I want you to put that in where the sale of my house is contingent upon me finding a house. Now, let's go through the options. The first of all, this is going to cost the client a lot of money. And so what I would say to the client is, and by the way, my typical pattern is when they say, can we make the sale of our home contingent upon us finding another home to buy? At the listing appointment, I'm going to say, sure, absolutely, we got a form for that, right? But as we get closer and offers seem to be coming in, I will have another discussion with the seller and I'll say, we don't really want to do that, to make the sale of your property contingent upon you buying another property, and this is why. If we make the sale of your property contingent upon your finding a property to buy, that's a big contingency for a buyer, because the buyer doesn't know if they buy your property, if they've actually really bought the property, because you may never find a property that you're going to like and move to, in which case they've been wasting their time. So if you're selling with that contingency, your offers are going to be lower than if you didn't have the contingency. I mean, obviously, if you were a buyer and there were two homes that kind of sort of were alike, and one of them you could just buy and move into, and the other one, if you buy, you may never move into it because they have to find another home. Obviously, you would go with the one where you could just move into. When would you take the other one, the one with the contingency? Well, it would have to be a really good deal. So by having this contingency on the sale of your property, you're going to lower the price that you're going to get from the sale of your property. But now you've turned around. I had a client who wanted to do this in Santa Rosa. Now you've turned around and you're going to Santa Rosa to buy a property, and that purchase is contingent upon you selling your house here. Now, again, this is not a good thing in that if there were the house in Santa Rosa, if the seller had two offers and they were relatively the same, and one was contingent upon them selling their home and the other one was not, obviously they'll go with the one that was not. When would they take the contingent one? It would have to be a fantastic offer. So by making the two sides contingent on this, you're going to get less when you sell your house, and then you're going to have to pay more when you buy another one. What alternatives are there other than thinking the person says, well, I can't afford to buy a house unless I can sell my house, and I don't want to sell my house if I can't buy. What do I do? Well, there are, if you talk to loan agents, they'll say, well, there's bridge loans, which are short-term loans, which have like hard money kind of interest rates, which are really, really high. There's what's called cross-collateralization. I've never had a client make those choices simply because they're very expensive loans. So what I recommend that clients do is I tell them, look, we're going to put your home on the market. We're going to set a date for when we're going to take offers and when it looks like we're going to get offers. What I want you to be doing during that time period is I want you to be looking in Santa Rosa, right? I want you to, don't be too picky, but I want you to at least feel comfortable that there are in fact homes on the other side that you would be willing to buy, right? Just feel comfortable. Now, what we're going to do is we're going to manipulate possession. So what that means is that when a buyer makes an offer to buy your home, we're going to ask for a 30-day, 60-day, something like that rent back. And by the way, if the market shifts, the rent backs will involve people paying rent, right? That could be coming, right? But anyhow, what we're going to do is we're going to delay closing. And once the contingencies have been removed on your property, with the buyer buying your property, now we're going to go to Santa Rosa and we're going to make offers. And the offer we're going to make in Santa Rosa is going to be presented as all cash. And where is our proof of funds for the all cash purchase in Santa Rosa? The answer is it's an estimated closing statement from the sale of your home that shows your net proceeds is greater than what you're paying in Santa Rosa. So we use that as proof of funds. Now, if it's already in escrow and it's already set to close and there aren't any contingencies and your net sheet shows that you're going to have enough money to buy and pay cash, it's not exactly an all cash offer, but you get the idea. We present it as an all cash offer, right? But don't make it contingent. Now, is there some risk involved in this? The answer is yes. But by checking this box, particularly if you're doing it both ends, right? You're not selling unless you can buy, and you're not buying unless you can sell. Those two contingencies could cost you $50,000, $100,000. Right? It could cost. You could. I told people you could stay in a nice hotel. You could put things in storage. The difference is going to be dramatic. Anyhow, if you check the box, the form automatically loads. Someday I might go through filling out the form. Here's a bunch of addenda. If it's a backup offer, you'd be checking that. Mostly you'd just be checking the ones. Probate, trust, short sales, I may be talking about what that is. The statewide buyer and seller advisory is generally included in the stuff that listing agents give you. If the listing agent has already given you one to sign, I don't necessarily do another one. If the listing agent hasn't done any of that stuff, we would want the buyer to have a copy of the statewide buyer and seller advisory. REO is a bank-owned property, something I might, talk about at another time. Other terms. What other terms might you be typing here? And generally, I tell agents you don't want to be typing a lot of stuff. This isn't a chance to write poetry or creative writing. The idea is to type less stuff. But let's say the buyer is getting a credit from the buyer's agent. That's something that needs to be disclosed to the lender. It needs to be disclosed to the seller. You could type that in here, right? But generally, we would leave it blank. Allocation of costs. There's a lot of fun in this section. The beginning of it talks about a natural hazard zone disclosure reports. Do I check the box buyer? Do I check the box seller? What's this environmental thing? What should I do? What should I type in? Well, first of all, let's say that the seller's already given you one. Then I would just not do anything, because what this is really designed for is if the seller hasn't given you one and you want one, and you might have a preference as to which of the natural hazard disclosure companies you want to use. I like Property ID. Some people like JCP. But if the seller hasn't given you one, you would fill it out, check the box. Usually this is something the seller would pay for. Environmental is included in most of them somewhat automatically, but you want that. And the environmental report is going to give you the location of any environmental hazards. Other reports, unless there's something weird with the property, you're not filling out anything there. Government requirements and retrofit. So generally you would click the box that says seller shall pay, right? And that would be for the smoke alarm, carbon monoxide insulation, and water heater bracing, right? That group would be something that the seller would normally pay for. Now, let's say, notice it says if required by law. There are some sales that are exempt, like a trust sale. Now, by a trust sale, I'm not talking about a family trust, right? Inter vivos, a living trust. I'm not talking about one of those. Those are just regular sales. But I'm talking about a vested trust, which means somebody has died and the estate is selling the property. Technically, they're exempt from these rules. However, the appraiser is going to call it. And if the buyer needs to get a loan, it's going to need to have those things, right? You understand? Maybe the law doesn't require that the seller do it, but it has to be done. So I've actually gone to Home Depot and bought a carbon monoxide detector and drove over to the house and stuck it in so that the appraiser could see it and say, oh, okay, there it is. So seller shall provide buyer a written statement of compliance, right? So written statement of compliance that shows, and that, by the way, is built into what document? This would be a bonus question. And the transfer disclosure statement actually has a statement of compliance where the seller is asked, are you in compliance? Paragraph 7B2 causes sometimes a lot of confusion. Should I check buyer? Should I check seller? Should I leave it blank? What is this talking about, right? What are we talking about? Minimum mandatory government inspections and reports. What are they? What are the retrofit standards? Where are they? Now, the impetus for this paragraph in the residential purchase agreement comes primarily from Southern California rules, where down in Southern California, there are some areas where if you sell a property, you have to have a minimum amount of insulation. And if you don't, you have to increase the amount of insulation. Up in our area, there's not a lot of these. Like, for example, Santa Cruz County has a rule that says that they have to certify that you're using the low flow toilets and that you're in compliance with their rules, and that's a point of sale. You're going to have to show them that you're in compliance, right? But Santa Clara County doesn't really have doesn't have any of these things. I typically would leave this blank unless it was in a county where I knew that there was one. I closed a transaction at the end of the year in Santa Cruz County. The seller already had, but this was something that was part of that agreement. But if I'm not in an area where there already is one, I would leave it blank. Some lenders don't like to see checkboxes here because they freak out as to what's going on, right? They don't know what's going on. They don't like it, right? So you could check with whatever county you're in to see whether or not there's something like that, but there's not very many of them in the Bay Area. The Santa Cruz has some, but it's not a big deal. Escrow and title. So agents are oftentimes saying to me, well, you know, I read contracts that agents have filled out. There are a lot of different sites to do this. I'm just giving a shout out to one of them. For example, when it comes to closing costs and things like that. So there's a website, and maybe all of the title companies have one. I'm a Chicago title guy, and it's called ChicagoTitleTransferTax.com. And what ChicagoTitleTransferTax.com does is that it'll show you, based upon the county, who pays for what customarily, right? Is there a county transfer tax? The answer is yes, everywhere. It's $1.10 per thousand. Who pays? Its seller pays, except in the city of Alameda, right? Is there a city transfer tax? Well, in Alameda County, sometimes there is, sometimes there isn't. It all depends on the city. And as you can guess, if you go down, you're going to find Santa Clara County, you're going to find San Mateo County, you're going to find Santa Cruz County, and Santa Cruz doesn't have one. That's nice for the sales tax. But the city transfer tax. But you would look here, right? Or wherever whatever your favorite title company, if they have something similar. I may be old, but I don't carry around pieces of paper that the title company gave me with who pays what customarily. I can pull up that other site on my phone, but how you fill this out would depend on what county you're in if you want to write an offer that is customary. Now, sometimes when you're looking at what's on the MLS, it's pretty obvious, right? It may be pretty obvious as to, what am I doing up here? How about this? It may be pretty obvious who the title company is. Some listing agents will just tell you, right? In the private remarks, they'll just say, escrow is with Old, Republic Title. They'll even tell you the name of the escrow officer. Sometimes you don't see it. So where would you find, if you're writing an offer right now, who the escrow holder and who the title company would be? Well, one thing to do is if the listing agent and the seller have provided a package, a disclosure package, see if there is a prelim. Right, a preliminary title report, because it'll tell you the name of the escrow officer and that sort of thing. If I don't know, I simply would type in seller's choice, right? And if I don't know who the title company is, I would type in seller's choice. Now, sometimes agents say to me, well, the property is in Alameda County and the buyer pays, so why don't we get to pick the escrow and title? That's not considered to be good form, right? Not necessarily. So if I'm a listing agent and I've already opened up escrow and I've already got a prelim and I've already done that, it's going to annoy me if you want to change escrow companies from the one I picked to the other one. Recently, I had an escrow on a transaction in San Leandro, and the buyer agent started out that way, and I was like, hey, come on, we've already opened escrow, and so they dropped it. But this is something that's negotiable. But even in the buyer pay counties, we tend to allow the listing agent, the seller, which means the listing agent, right? You know, the question is, who picks the title company? Who picks the escrow company? Well, without getting philosophical, the short answer is the listing agent picks, right? That's who's picked. And unless you have some real strong reason to change, just go with that. If you know the name of the title and the escrow company, write it in. If you don't, just put in seller's choice. So there's a seller transfer tax, the county transfer tax, which the seller shall pay. It is customary in most of the counties, a few exceptions in the city of Alameda, where the seller pays, so you would check that. If it's a city transfer tax, like in Santa Clara County, the buyer and seller split it, which means we would check both boxes, and then I would write in split 50-50, just to be sure, right? Just to be sure. And then if there's a homeowners association, usually the seller will pay for the homeowner association transfer fee. If it's a homeowner association, the seller typically would pay for the fee for preparing the HOA doc. Is there a private transfer fee, right? Well, you can look at the prelim, but there are not very many, but there are some subdivisions that created a transfer fee. Should be on the prelim, not always. This is not a very common thing, but typically that would be something the seller would pay for. Unless something weird is happening, you probably aren't writing in anything for 8 and 9, asking the seller to pay for other stuff. Again, what I'm doing is going through the standard basic, how to fill out the form. Obviously, there could be issues with a given transaction that would require more. Now, is there a home warranty on the property already? In my listings, I tend to persuade the seller to take out a home warranty during the listing period. This is called seller's coverage. That way, if something breaks during the listing period, there's a home warranty, right, in place. Now, if you don't do this, right, if you're a listing agent and you don't do it, you never mention it, that's something the buyer can buy. If the buyer wants it, the buyer's agent can buy it. You don't talk to the seller about this. What could happen is this. While the property's on the market, the furnace breaks. And you say to the seller, gee, that's terrible. That's too bad. You know, you're going to have to get that fixed if we want to sell, you know, your house, right? And it may be, let's say, $1,500. And then the seller is at work, and one of the seller's friends at work is saying, how is the sale of your property going? And the seller says, well, you know, we just had a bump, you know, the heater broke, and, you know, I'm going to have to pay to have it fixed. And the coworker says, well, what do you mean pay to have it fixed? Why don't you just call the home warranty company and have them fix it? And the seller says, I can do that. And the buyer says, yeah, the friend, excuse me, says, yeah, I'm sure your agent has covered you during the listing period. And then the seller calls their agent up and they say, is there a home warranty on the property right now? And the agent goes, huh? What are you talking about? No. Well, I hear that there's a home warranty that protects the seller. Do we have one? And the buyer says, the agent says, no, we don't have one. And then the seller is kind of angry. And the seller is like, you should have told me, you should have given me the option. If you'd given me the option, I would have gone for it. Now I have to pay $1,500. It's not fair. You screwed up. You should have. So what I do on the listing appointment, after I've signed all the documents, is I actually give the seller 3 home warranty brochures. And I tell them that I explain what seller's coverage is and why they might want to have one. And I can remember a seller coming back to me and said, I read them, I don't really think it's a big deal, I don't want it. And you know what happened? His heater broke, right? And I, didn't say I told you so, right? You don't have to, but you understand this is a very different conversation because I mentioned it. I encouraged him. He just chose not to do it. That's not my problem. But if I don't mention it and they therefore don't do it and something breaks, this could easily become my problem. Now, the other advantage of having this, if you represent the seller, is that you can tell the buyer's agent that you already got one, right? And by the way I sell this to a seller is I say, you don't want to end up in small claims court just because something broke. It doesn't cost very much. It's insurance. It's a good deal. Now, there's also a hidden agenda. And with the hidden agenda that I have is that whoever picks the home warranty company, by that I mean whichever agent picks the home warranty company, the home warranty company is going to be sending marketing materials to the buyer of that house. And if, as the listing agent, I'm the one who set up the home warranty company, then that buyer is going to get stuff from the home warranty company mentioning me, but not mentioning the agent that represented the buyer. So it depends. If the market softens, you'll see the seller shall pay a lot more. And how much should the seller pay? I don't know, right? You might say not to exceed, I typically write in $500. Now, if I'm representing the buyer, and there's an air conditioning, a pool spa, and things like that. And here, let's say I'm representing the buyer and the seller hasn't provided a home warranty. So I'm going to write it this way, and I'm going to write in buyer's choice for issued by. Now, if I, as a buyer's agent, buy the buyer a home warranty, I buy the best plan that's available. I buy the plan. If they've got an air conditioner, I'm going to check the air conditioner. I don't want the basic plan. I want the platinum plan. Because what I want is if something breaks and they call the home warranty company and then hear, oh no, that's not covered. You see, your agent got you the basic plan and the basic plan doesn't cover things like that. Now, this has not been a good public relations event, right? You understand, I would like it to be the best plan possible. So even if I have to do something to upgrade it or whatever I want, if I represent the buyer, I would like the best plan possible. Figure out what that would be, and write it in, and then you want to be the one to pick the home warranty company. You could just, let's say you're going to buy the buyer a home warranty company, you don't really care about this, then I would just check this box, right? And this doesn't mean that the buyer couldn't get one, it just means we're not putting it in as a condition of the contract. I do this like not an all-day class, it just seems like an all-day class, but a really long session, let's just say, on home warranties, right? And what they cover and what they don't cover. They could be a source of either goodwill or, for that matter, embarrassment. Items included and excluded from the sale. All right. First of all, you need to know that just because the MLS or the marketing materials say something, that is not necessarily what the contract says. All right, so the MLS says you get the refrigerator and the washer and dryer. That doesn't matter, right? It's what the contract says, right? And notice it says, except as otherwise specified or disclosed, all existing fixtures and fittings, and then existing electrical, mechanical, lighting, plumbing, heating fixtures, ceiling fans, fireplace, it's a really long list. Now, over the years, I've gotten more, focused. I'll give you an example. So everybody can see the list, right? I sold a house And in the backyard, in the garden area, there was a green cement, like a bench, right, where you could sit on it and look at the garden. A green cement bench in the backyard in a garden area. Is that included in the sale or not? In this case, the seller took it with them. Buyer is like, hey, where's the bench in the backyard? Let's see. Does it include, it says in-ground landscaping. That's not really tree, shrub, water features found, water softener, water purifier, security alarms, if checked, stoves, whatever. Notice it doesn't say anything about stuff in the backyard. Patio furniture, right? Which generally would go with the seller. How about, have you ever seen people in the backyard and they have this great big, like pot, a great big cement plant with like a huge tree, something really, really heavy? Is that included in the sale or is that not included in the sale? So one of the things that I've learned to do is if there's anything that is even iffy, I write it in. I sold a house as a townhouse, and on the wall was a candelabra, right? It was like driftwood that would come up. It went up like a big pole, and there were pieces of driftwood that would stick out, and there were candles on the piece of driftwood. And this thing was attached to the wall by like a little bolt so it wouldn't fall over with the candles and set fire to the place. So we sell, I represent the seller, we sell the townhouse, the buyer moves in, and the seller has taken the candelabra with it. And so the buyer's agent is calling me and where is it? And you can't take it. And I'm like, that's a decoration, right? If that were an original Monet or a Renoir painted and it was bolted to the wall so people couldn't steal it easily, would you expect to get that too? Right? You're saying it was a decoration, and you don't get decorations. So he goes back and he says, wait a second, it's a lighting fixture, right? Because it had candles, and I'm like, this isn't the 1800s, so you get where I'm going with this. If there's anything that looks iffy, I have this belief, and right now people are going to Home Depot is not even easy, but I have a belief in normal markets, if you were to park outside of Home Depot and you're looking for people coming out in business casual attire who have purchased fireplace screens, the little tools and things like that, patio furniture, and you stop them and ask them what they did for a living, you would find real estate agent comes up more than our percentage of the general population. Why? Because the buyer moved in and something they wanted wasn't there. Right? I'm just saying. Now, if there's stoves, are they included? Usually, yes. If there's a refrigerator, is it included? All refrigerators, what would be an exception to that? Well, let's say there's a refrigerator in the man cave, a refrigerator in the woman cave, a refrigerator in the garage. That's usually not because it's plugged in, right? It's not like that might be an exception. Are there washers and dryers? Again, there might be, but you'd want to fill that out. Anything else that all of the garden furniture, all of the patio, here is a chance for you to write them. Integrated phone automation systems, whatever, are included. So internet things that are inside are generally included unless you check that and tear them out. This is one that's a lot of fun, leased or liened items. And we're going to start off with another seller shall. Within the time period specified in 14A, that's 5 days, disclose to the buyer if any item or system in 8B, that's up here, Otherwise included in the sale is leased or not owned by seller, or specifically subject to a lien or other encumbrance. And then delivered to the buyer written materials, including the lease, a warranty concerning such items. Here's the kicker. Buyer's ability to assume any such lease or willingness to accept the property subject to any such lien is a contingency in favor of both buyer and seller. This is unique in the residential purchase agreement because the other contingencies are either for the buyer or they're for the seller. They don't say for the buyer and seller, but this one says for the buyer and seller. So let's say what we're talking about are solar panels, all right? In case you're wondering, what are we talking about here? Solar panels. So let's say your buyer is buying a house and there's solar panels on the roof. Is that great? Isn't that good? Well, maybe. Because does the seller own them? Is the seller leasing them? Or has the seller got a loan to put the solar panels on the roof? Now, if the seller owns them, there's less issues involved. If the seller is leasing them, then the seller is supposed to give to the buyer a copy of the lease agreement. And then what sometimes I had a transaction where what the buyer did is they looked at the lease, they looked at the name of the solar company, they Google searched it. And what they found is that they have terrible reviews. Some of the solar companies have terrible reviews. And it's a older system from a company with terrible reviews. And so the buyer said, nah, we don't want it. Now, the lease contained an $8,000 buyout if you wanted to buy out the lease. In other words, if the buyer does not continue with the lease, there's $8,000 that has to be paid to the solar company. Who pays for that? Now, you'll notice it doesn't say, right? It doesn't say. It simply says that the buyer's ability to assume such lease or willing, it just has to be worked out. So if there's solar panels, this isn't necessarily a reason to cheer yet. If they're leased, you need to look at the terms of the lease. Now, what the solar companies also most likely have done is they've recorded the lease as a fixture, as a recorded fixture on the property. It'll appear on the preliminary title report. That means you're not selling the property until you work out who's going to take over the lease. And although this may sound bizarre, sometimes it's easier for your buyer to qualify for an 80% loan than a solar lease. And I know it sounds bizarre, but the solar panels are generally depreciating, right? Every year they make them cheaper and better. So old solar panels are a depreciating asset, and sometimes the buyer can't qualify for the lease. If a loan was used to buy the solar panels, particularly if it's a loan called a PACE loan, we've got more problems. Because a PACE loan is considered a super priority loan, which means that it must be paid off before escrow can close, which means not that it gets paid off when escrow closes, but that it is paid off before escrow can close. So the lender won't fund if there's a PACE loan unless the PACE loan has been paid off. That means somebody has to pay off that loan, or the lender will never fund their loan and the property will never sell. I spend some time helping agents work through this because there are a lot of issues that can come up from the existence of solar panels. Seller represents in 6 that all items in the price are owned by seller and shall be transferred free and clear liens except for the terms and conditions of 8.5. That means solar panels. And it goes on to talk about, you get the big screen, television, what do you get? And what it says is that unless otherwise specified, the following items are excluded from sale. and that includes flat screen TVs. If such item is not attached to the property, even if a bracket or other mechanism attached to the component item is attached to the property. So if there's a bracket and it's attached to the wall, you will either click remove them, or they're supposed to be left so somebody can, I don't know, hook something up on the same bracket. But if you check the box, you're asking them to remove, people just generally remove the brackets anyhow, but I'm just saying that, do they fix the wall? You know, that's addressed in the last part of paragraph C. Closing and possession. So does the buyer intend to occupy the property as the buyer's primary residence, yes or no? Now, buyers generally want to check the buyer intents because they're going to get a better loan. We're not, of course, encouraging people to commit fraud and not check the box when it doesn't apply. However, I'm just saying sometimes the buyers don't want to check the box simply because they get a better loan if they tell the lender they're going to live there. Now, depending upon the property they currently own, are they downsizing, right? So will the lender believe them if they own another property? Will the lender believe them when they say, we intend to move into this one? Will the lender believe them? And the answer is sometimes they'll just believe them. Why would a lender just take their word for it? Well, first, if they're downsizing, if there looks to the lender like a legitimate reason for them doing this, and if the other property, can they qualify for both loans? Let's say the house they're living in right now has a loan on it. They're getting a loan to buy this property. If they're not going to sell their existing one, then can they afford to carry the loans on both of them? And sometimes with the lenders, if you say to the lender, well, I'm going to rent out my other house, right? Some lenders will just believe you, but sometimes they'll say, well, prove that you're renting out your other house. And by the way, just for qualification purposes, the rental income projected from your current residence, they won't give you 100%. Let me see. Who usually pays the lease of the solar panels before it closes? That, by the way, is a good question. And the answer is it depends. The last one I did, they split it 50-50. The seller wanted the buyer to pay the $8,000. The buyer wanted the seller to pay the $8,000. They eventually split it 50-50. That can be negotiated, who pays off the lease, right? You'll notice it doesn't say here who's going to pay off the solar lease, right? That would have to be negotiated. What that means, by the way, if you're the agent of the buyer, you should read all that stuff that the listing agent gave you. You should look at if there's a solar lease, you should read it. And what you're really looking for is how long does it last? Some of them go on for like eternity, it seems like. And what happens if the buyer doesn't want to continue it? How much is it? That would be something that you would need to negotiate. All right. So back to the closing and possession. So the buyer already has a house. They tell the lender that I'm going to be moving into the new house so I get a better loan. The lender, they're also wanting to rent out, they say at least they're going to rent out the house that they currently owned. And let's say it's $4,000 a month that they're going to rent it for. The lender's not going to give them credit for $4,000 of extra monthly income. They give you 70% because people don't always pay on time. You may be vacant, whatever. And sometimes the lender is going to require, if you tell them that you're renting your current primary residence, but moving into this one, they're going to want to see a copy of a signed lease agreement. And they're going to sometimes want to see that whoever the lessee is, the tenant, that they've actually made a deposit towards, they've made the first month's rent. Now, I'm not saying this is something that we would ever encourage. However, it is quite possible that some people have gotten a friend to sign a lease agreement they downloaded off the internet, give them a 1 month's deposit, which they eventually give back to them, because essentially the underwriter is going to check it off. They generally don't come by and peek over, your fence to see if you're living there. but this can become a big issue. Somebody that wrote an offer on one of my listings recently, I don't know if you know this, but interest rates right now on non-owner occupied loans have gone up dramatically. Like we're talking about 4.85, we're talking to up to 6% interest depending on the lender. They're much, much higher than a owner occupied purchase loan. Right, so this is just, I'm just saying. Right? I'm just saying. Seller occupied or vacant property, possession to be delivered at 6 p.m., date of close of escrow, no later than so many days after the close of escrow. So we're going to talk about what happens if the seller remains in possession. A cheap, easy way to do it is to check that box and say, all right, 14 days, whatever, right? And you would just simply type in, no later than, let's just say 14 days. The most that a lender will allow the seller to stay there is usually 60 days. Otherwise, you've checked the wrong box, which is it's not an owner-occupied property. Now, there's a form that would go with this if the seller was staying. It's the SIP form, which is the seller in possession. If seller has the right to remain in possession, the parties are advised to sign a separate occupancy agreement. Now, I'm not saying this happens all the time, but that people actually go to the trouble to do this. Sometimes they just write in up there 14 days. Sometimes agents just type it in the poetry section where it said terms, the seller to have 14-day rent back, right? Now, the seller in possession form, which is something designed for less than 30 days, ask questions like who's paying for utilities and what about insurance and other annoying questions that might be a good thing to look at. If it's going to be longer, you use the residential lease agreement, which is for more than 30 days. That's a regular lease agreement. So it would probably be a better practice to check the box and do the seller in possession form. Some agents don't because they're hoping that nothing's going to go wrong and they just write in 14 days. Notice it says buyer is advised to consult with buyer's lender about the impact of seller's occupancy on the buyer's loan. Oh, yes. That's a very good idea. You should talk to your loan agent and say, is this okay? Right? What's going, and just, call them up and ask them. If it's a tenant occupied property, the listing agent and the seller are doing it wrong. If you represent the seller, you want to get the tenants out, right? I know, I've heard, oh, the money, I need the money, and they're going to cooperate. I'm just saying you want to get the tenant out. Notice it says if you are unable to the seller to deliver property vacant in accordance with rent control and other applicable laws, you may be in breach of this agreement. Rent control and other applicable laws, unable to deliver rent control. So one of the provisions of the rent control rules, and there are some variations by county. I have a listing in Oakland, put it in this morning, I think it was. And Oakland actually has very tough rent control laws, but there's a part of the rent control law that deals with unjust eviction. And what unjust eviction means is just because somebody is selling the property, that doesn't mean the tenant has to leave. If the tenant has been there for more than a year, they can't just be kicked out simply because the seller is selling the property. In some areas, like in Oakland, there's a very limited number of reasons that you could kick the seller out. So for example, if you're buying it to live in it, so for example, you've checked up here in 9A, buyer intends to occupy the property. The owner occupying the property is an exemption to the rent control rules, which would allow you to give notice to the to the tenant and get them out. It's an exception. However, you might have to pay the tenant a relocation expense, right? You might have to somebody has to give them money in order to get them out. Who's doing that, right? Who's going to make sure that so this is something that you would want to negotiate. If it says that there's a tenant in the property, you would want to find out from the listing agent, how long has the tenant been there? And is the tenant been given notice? Is the tenant going to be moving out? Because just because the property is being sold doesn't mean you necessarily have the right to kick the tenant out and and particularly if you want to rent it to somebody else for more, ooh, that's a big no-no, right? One of the exceptions is if you are moving into it. Now, there are in Santa Clara County and in many counties, the rent control rules do not apply to the sale of single-family homes, condos, and townhomes. They apply to more than that. In Alameda County, in Oakland in particular, and in other areas, they have more strict rent control rules, and it applies to single-family homes. It applies to everything, and you would want to know this, right? I'm just saying, you would want to know in your area, does the rent control limit your ability to evict somebody? Right? It doesn't. And you need to deal with that. Sometimes the tenant's going to stay there. If you're selling a fourplex, a lot of times they want the tenant to stay there because that's where they're going to get, the rent from. So at close of escrow, seller assigns the buyer any assignable warranty rights. They shall deliver the buyer any copies of such warranties. The brokers cannot and will not determine the assignability of warranties for appliances and solar panels or whatever. It's are there warranties? Can they be assigned to the buyer? If so, the seller agrees to do that, but we don't know, right? We're brokers, we don't know. At close of escrow, unless otherwise agreed in writing, seller shall provide keys, passwords, codes, other means to operate all locks, mailboxes, security systems, alarm, home automation, internet connected devices included in the purchase price, and garage door opener. Buyer may be required to pay a deposit if there's an HOA. Paragraph 10 is the list of the statutory disclosures. Notice it says seller shall, within the time period of 14A, we're going to be coming to that, that's 5 days. If required by law, a lead-based paint disclosures form, the federal lead-based paint disclosures, and that is required by law with the pamphlet if the property was built before 1978. If it was built before 1978, there's a good chance that there's lead-based paint. If the buyer does not get a copy of the pamphlet and the lead-based paint disclosures, the buyer can cancel the agreement. It doesn't matter that the buyer made an offer without any contingencies. There are statutory contingencies that cannot be waived. Question. What if there's a renter who doesn't have a rental agreement? What is the process to get them out? First of all, see you online, Weedad. If the renter doesn't have a rent agreement, first of all, if you're paying rent on a monthly basis, it's an implied lease agreement, and it just is. And you, depending on how long they are there, you have to give them notice. In the cities that have like serious rent control, they don't care if there's a rent agreement or not. They do not care. Right? If somebody is there and they're paying you rent, it's covered by the law. So this is why if you're the listing agent and you're representing the seller, the best thing would be to get the tenant out before you put it on the market. Because let's say that the tenant just doesn't leave. Right? Escrow is supposed to close next week. The tenant has not packed, isn't moving, isn't doing anything. What do you do? Now, assuming you've given them the correct, notice, if they will not get out, you have to file, you give them a 3-day notice to pay or quit. You have to file an unlawful detainer. You have to take legal action to get them out. Which is why whether there's a signed rental agreement or not is not important in terms of the rent control law. Is the lead-based paint in the natural hazards? The answer is yes. It's one of the standard things that's in that package. And in zip forms, there's a way for you, I think I did this in the first class, where you can add those. Now, even though it's called EPUBs, and it's part of ZipLogic, which is where we write the contracts from. I know a lot of times real estate agents get the buyer to sign the receipt, but never actually give them copies of all of the disclosures. And the law says that if the buyer is not given this disclosure and the pamphlet, the buyer can cancel the transaction. It doesn't matter whether there are contractual contingencies or not. Good question, though. There are other statutory disclosures. The real estate transfer disclosure statement, the TDS, the natural hazard disclosure statement, the NHD. If there's a Mello-Roos, which is, I don't know, a kangaroo that's taking antidepressants, I'm not really sure. These all, by the way, the Mello-Roos, which is named after actually two politicians, and the Improvement Bond Act, and all that sort of stuff. If you run an NHD report, even though this doesn't seem like a natural hazard disclosure, if you run an NHD report, they typically disclose these sort of things as well. What else is on our list? By the way, in the question, thank you, good to see you too, it mentions earthquake, a homeowner earthquake. So I'm sure you all know this, but if the property was built before 1965, if it was, 1960, if it's a wood frame residence, or 1975, if it's a brick building, a masonry building, any property built before 1960 wood frame, the seller is required not just to give the buyer the pamphlet, but to fill out an earthquake disclosure form. If the property was built after 1960, technically that's not a legal requirement. Now, if I'm a listing agent, I generally fill it out at the beginning, whether it was built before 1960 or not, because what will happen is the buyer's transaction coordinator, you're getting ready to close escrow, and this is on the list. And if I'm the listing agent and you call me up and you say, look, we don't have the earthquake disclosure, isn't filled out, and my broker says that if I don't get one, that I'm not going to get my commission check, will you have the seller fill it out and give it to me? I'm going to say no. Right? If the property was built in 1975, 1980 or something like that, I'm going to say no. Because if we give you, from the selling side, if we give you a new disclosure around the time escrow is about to close, that triggers in the buyer a right to back out of the contract. Right? It triggers it. So unless the contract makes me do it, or the law makes me do it, I ain't gonna do it. Right? Now, I've mellowed over the years, and so I generally get the seller to fill out those forms in advance, so that we can give them to the buyer before the buyer writes an offer, so we're not arguing about it. But those are a lot of dates to remember: 1978 for the lead-based paint, 1960 for the special earthquake disclosure. And if you don't do it, by the way, let's say the property was built in 1947 and the seller never filled out that form, the buyer can cancel the agreement. So when is the disclosures complete? It says it's considered fully completed if seller had answered all questions and completed and signed the seller sections, and the seller's agent, if any, has completed and signed the AVID, the agent's visual inspection disclosure. Let's just stop there. When is the seller property questionnaire and the transfer disclosure statement considered to be completed? When they have answered all questions. So I was involved in a transaction. The house was in Sunnyvale, single family home. The buyer buys it without any contingencies. It was, it was that market. We represented the seller, and the buyer's an engineer, and what the buyer notices is that what the square footage of the lot in the prelim is different from what it says in the MLS. And when I checked with the listing agent, the way she had gotten it was it was imported by the MLS from tax data automatically. The agent didn't type in that number. The seller didn't come in the number. MLS listings software produced that number. And if you look in Realist, it has the same number that was in the MLS, but if you look in RPR, it has a different lot size. There is a discrepancy. So the engineer buyer goes out and measures the lot, and determines that it's the lower number, not the higher number. The higher number, of course, is the one the MLS has, and that the lot is actually 400 square feet smaller than what it said in the MLS. But you understand the buyer has no contingencies. And we had given him a copy of the prelim, and the prelim had all this information, but nobody bothered to really read it, and until after they were in escrow. So the buyer comes back, and the buyer wants money, right? They wanted 18,000, I think it was, because they're being cheated out of 400 square feet. And I'm talking to the seller. I'm helping the agent that had listed it with this transaction, and the seller says, no way, no, we didn't make that up. We didn't do anything wrong. And so the broker for the agent of the buyer goes through all of the disclosures the listing agent has provided, and notice that in the seller property questionnaire, the seller did not answer, had neglected to answer 2 questions. In the seller property, the SPQ, the seller property questionnaire, the seller did not answer 2 questions. So the agent gives us a notice to perform, answer the questions. And then, of course, when we do that, they say, now we have 3 days to, you've modified your disclosures, we have 3 days. Now, they didn't get their 18,000 and we closed anyhow because, and I'm just going to finish this paragraph and then we'll be done today, because later where it talks about the contingencies, there's a clause that says it has to be done in good faith. And what I said to the buyer's agent was the answer, when the seller answered the questions, was no. Right, so there was no new information revealed by the seller answering these questions. The buyer, it is clear from your emails, is not backing out because of that. They're backing out simply because you want $18,000 because you don't like the lot size. Notice it says the buyer is supposed to conduct their own investigations as well. Waiver of statutory and lead-based disclosures is prohibited by law. I already mentioned that. Even if the seller is exempt from doing a transfer disclosure statement, like in a probate sale or something like that, there's an exempt seller disclosure, which is sort of a SPQ light. Notice it says the buyer shall, within the time period in 14B1, which is 5 or 7 days, return signed copies of all of these documents. This is one reason that the listing agents kind of want them at the beginning. We're going to talk more about that when we get to contingencies. If anybody finds anything new, any material inaccuracies, information, or representations, seller shall promptly provide an amended disclosure or notice. Notice it says, however, a subsequent amended disclosure is not required in which the buyer is otherwise aware and if they're in reports. If you're representing the seller, you want to get a property inspection, you want to get a termite inspection, a roof inspection, a chimney inspection, you want to get all the inspections and you want to give it to the buyer in advance. And if you do that, then anything that is included in those inspections and reports is considered to be included in the transfer disclosure statement in the seller property questionnaire. Notice if anything is subsequent or amended disclosure, they have 3 days after delivery in person or 5 days, they have 3 days to cancel the agreement. You understand what that agent was doing representing the buyer? The seller hadn't answered all the questions. Now, by the way, if I represent a buyer and I see that the seller hasn't answered all the questions, I don't necessarily tell them that at the beginning of the transaction. I just don't say anything. Because I realize that by them not answering all the questions, they may have given us a get out of escrow free card, because at some point we can demand that they answer the questions. And then this says that we would have a right to cancel as a result, which would give us a little bit of leverage. I went over a few minutes. Tomorrow I'm doing a special thing about selling real estate in the age of the COVID. I'm sure you probably received invitations on that. That'll be at 11 o'clock tomorrow. Next Thursday, we're going to finish this. It's getting lighter now. There's a lot of stuff that there isn't much to say. And then I'm going to go through how to go through this with a client using software you already own for remote. You don't need Zoom. You don't need GoToMeeting or GoToWeb. You already have software that's built into your CIR zip form subscription, how to get it signed, how to explain it, how to do all that. So that's enough for today. I hope you found that to be a useful and fun discussion, and I'll see some of you tomorrow and maybe Thursday, and I don't know, maybe again.